Welcome to the seventh panel of the EDPS Enforcement Conference titled, Is Digital Sovereignty the New GDPR? Question mark. Gotta intonate the question. My name is Przemysław Pałka. I'm an assistant professor at the Jagiellonian University in Krakow, Poland, where I direct a project called Private Law of Data funded by Norwegian grants. And I'll have a distinct pleasure and honor to moderate this session devoted to the question of digital sovereignty. Digital sovereignty is a concept that has been growing in popularity lately. Different people use it to mean different things. Broadly understood as a factual and legal ability of individuals and communities to control data concerning them. It's being mentioned by politicians, mentioned by scholars, and we want to talk about it today. The questions that we want to ask range from whether this hype, this growth of popularity of the concept of digital sovereignty has something to do with the fact or with the feeling that the GDPR enforcement has been suboptimal, whether if we want to actually achieve the digital sovereignty of this union, what is the role that GDPR enforcement has to play in that process, and more broadly, what is it that we actually mean by it? Who stands to benefit from achieving it? Who stands to bear the cost? How does it look in the geopolitical stage? Those are important questions. Those are difficult questions. But fortunately, we are joined by a stellar panel of experts and speakers who will help us address them. So please join me in welcoming our speakers. On my right, Chloé, Berthélémy, who's a policy advisor for EDRI, European Digital Rights, representing civil society. Karen Melchior, who's a member of European Parliament from Denmark, the Renew Europe group. Xavier, who's the legal director for the OVHcloud, representing the private sector. And Christian de Cunha from European Commission, head of the DG Connect Internal Task Force for Cyber Crisis Coordination. Let's give him a round of applause. And I'd like to begin this session by helping us all to get at the same page as to what is it that we mean or we might mean by mentioning digital sovereignty. What do we understand by this concept, or what could we understand it in order to advance the digital rights of our citizens and the security of our union? And if I could ask you, Karen, first to share your perspective on this question.
I think there are as many definitions of it as there are people talking about it. For me, it's a lot of ensuring that the European legislation is actually enforced also in the digital sphere as well as in the physical sphere, and especially when it concerns fundamental rights for citizens, that we make sure that these are being respected also if we're using non-European service providers. And I think actually the answer to the question of the panel is actually that GDPR is the expression of digital sovereignty, because GDPR is European legislation that has a global impact, because we are the norm setters and we went first in the European Union, and it has had an effect. And I think we'll see some of the same in I think there's a problem. There we go. That there is that we'll see some of the same with the Digital Services Act that has just been agreed. And I think this is part of the way to go forward, rather than looking at it as a protectionist measure to ensure European companies.
Thank you very much. On this intersection of both passing the law and having the technical capability, Xavier, would you mind sharing your perspective from someone who's participating in this market?
Yeah, I would like to maybe get some feedback more and step back a little bit before GDPR. Actually, data protection regulation comes far from a long time ago, and GDPR is just the next level. And what we noticed as a company is that suddenly in 2018, we have a lot of people talking about data protection, but actually this is a long process. And I spent 22 years in a digital world in private company. And this is a topic we talk a long time before 2018. So actually inside a company, a private company, this is something which is a process which get an achievement with GDPR at European level, and has two kind of comprehension, two level. You have data sovereignty, which is more related to the choice, the freedom of choice we can give to our users. And we have technical sovereignty, in which you can find the fact that we are not dependent of a third technical company or technology. So as a European company, we embrace both part of that concept, and we already be interoperable. We have the interoperability, reversibility, portability, and all that kind of concepts we already follow and explain to people and users. We have open standard. We have certification given by national authority. And we also have something which is maybe not very known. We have a complete control of all our chain values because we built our own server. We have factory in France. And that's the way we actually taking GDPR as part of the digital sovereignty.
Thank you very much. Christian, following on this point where digital sovereignty is just one point in time on the timeline that started a long time ago with European regulations and is definitely still work in progress. What, from the European Commission point of view, how do you see this concept? How do you think you guys see it? How do you think others or actors see it? What are your thoughts on the concept of digital sovereignty?
Well, I did check, but I don't think the Commission has a formal line on or definition of what digital sovereignty is. However, it does appear in policy documents. In the cyber security strategy from 2020, the first chapter talks about leadership, technological sovereignty, and resilience. And it's fair to say that a lot of member states talk about it all the time, and some of them would never use such terms. Our Commissioner Thierry Breton certainly talks about it a lot. He's talked about recently informational sovereignty being a thing in the same way as sovereignty of territory and the seas and air is a thing. But it has I think the reason we're having this discussion is as is mentioned in the introduction, it's about geopolitics. And there's a former director of ours, Paul Timmers, has published a paper last year where he scanned references to data sovereignty, technological sovereignty, digital sovereignty over the last 20 years. Before 2011, you hardly saw any. It was like 100 in policy documents. By 2015, it was 3,000. So it's probably misplaced to think that the GDPR was I don't think the authors, thinking back to 2009, 2010, I don't think they were thinking about big tech as such. I don't think that term was even in currency. I think it appeared around 2013. So, I mean, there's a lot of discussion about sovereignty in the sense of technology and chips in particular. You've seen the CHIPS Act, which is an enormous initiative trying to boost Europe's presence in the market for microprocessors. But where it comes to data, it's a similar thing. It's trying to reduce vulnerability to supply chain shocks. And I think it can easily apply to data equally, that you're running risks if you put data in places that you can't guarantee it's going to be looked after.
Thank you very much. Chloé, from the digital rights, fundamental rights perspective, how would you understand this concept? Where do you think it can be useful?
Sure. The concept of sovereignty, I think we see it mostly as a question of power, that we're facing some sort of power struggle, and mainly the two actors that are in this struggle are private companies on one hand, and the other one is states, governments. And so how we see the kind of concept developing in the debate, especially in the recent years, mostly at European level, is really in terms of control. There we kind of observe a realization from governments that they seem to have, they came to the realization that maybe they lost control over certain tools, over certain digital infrastructures, and even further around the production of certain norms and standards, and that they delegated a lot of these powers to define how digital tools, infrastructure, and standards are developed to the private sector. There is one thing about like being in control and being able to apply the laws that you're making, and deciding on your own territory. But there is also a question of autonomy and independence, like Xavier mentioned, this fear in the narrative that we are relying too much on foreign actors, and therefore we're losing control over what we're using. And that was kind of clear in the COVID time, during the pandemic, when we had to develop COVID tracing apps, for example. We came to the realization that maybe we're a bit too much dependent on the big ones, on the Googles and the Apples for that. And unfortunately, we have a trouble to get out of this framing sometimes, and especially recognizing that it's a very binary framing, like big tech versus government, and how the two are like struggling together. And we completely put aside the users or the communities that are actually using those tools and are like the beneficiaries of digital infrastructures. And therefore, as a kind of fundamental rights perspective, we would like to invite to rethink and question maybe if this is a right term and frame to actually enforce people's right. Do we really need that? And is it gonna bring more enforcement of people's right? At least we would like to question this assumption. And also we regret that the main framing is also around, from the member states mostly, in economic terms. We're completely putting aside the rights, and we're very much here about like, we need to build our own European champions. We need to have to be an economic force behind this in the digital market. And all the consideration about rights and freedoms are put aside, and this is quite disappointing so far.
Yeah, thank you very much for this intervention. So that directly following from this point, when preparing for this panel, I read several dozen speeches, documents, etc., using this term, and obviously various actors use it in various ways. But it seems to me that on the one hand, there is the mention of rights of our citizens, of our residents. There is the mention of security of our union, security of our infrastructure. But at the same time, there is this talk about exactly building the champions, the arms race with China and the United States. And one has to wonder which part here is the actual motivation behind the digital sovereignty narrative, and which part is just the narrative trying to present the motivation as something maybe more noble than it is, right? Because one could imagine that instilling this digital sovereignty is a kind of tariff that we put on external actors because we've given up on this dream we had still when we started talking about GDPR, where through globalization we sort of export our values. And we realized, maybe it doesn't really happen. So we have to just support our own actors. Or maybe not. Maybe it's actually possible to arrive at the two. And I was wondering, Kristen, if you could kick us off on that. What do you think are the motivations of various actors behind this narrative of sovereignty?
Well, I mean, going back to geopolitics, I think the prevailing wind globally is fragmentation, and when it comes to data, that means data localization. It's a fact. It's happening around the world. our commissioner, reflecting on the pandemic, said that the belief in reliable supply chains had been shattered by the China first for masks and America first for vaccines slogans that were being touted around at the time in 2020. And I think we are finally waking up and smelling the authoritarian coffee, the fact that everything is connected. So every time we flick a light switch, we're potentially funding Russia's military aggression. If we buy a product along the supply chain, we may be funding repression in Xinjiang. So if there is a decoupling and a deglobalization taking place, and it's not altogether clear that it is, it should present opportunities for coupling more closely with partners where they have democracy, rule of law, and respect for human rights. And I think what's happening, and these are obviously all personal views, but I think the consensus of a world, I would caveat Chloé's point. I know what she's saying, and I sort of agree, but I think the consensus of a world driven by economics and trade is disappearing. And I think we're moving towards a policy environment where values determine how tech is designed and how data is processed.
Thank you very much. Karen.
I think we went back in history a little bit when we talked about GDPR before, and I think if we go back even further to 2005, 2006, the negotiations in the World Trade Organization sort of collapsed. And I think what we're also seeing is a loss of belief that we have international organizations that can cover the legal framework globally. And this fragmentation has led to trying to have more regional partnerships. And that this talk of digital sovereignty started when this also sort of started. Mark Leonard from the European Council of Foreign Relations recently, in November last year, wrote a book called The Age of Unpeace. He said that the connections that we have, the rivalries that we have, allow us to enter into conflict with each other. As was mentioned earlier in COVID regarding personal protection equipment, and also, I mean, with things such as sort of Stuxnet and also sanctions. And there, I think we need to look at partnerships with countries and regions that share our values. And I think the Technology and Trade Council with the US and Europe is part of what the solution could be. I think there we have an opportunity of sharing values and also sharing commerce. The comment on the COVID tracing applications, I think actually the Google's Android phones and Apple's iOS systems were actually providing more privacy for the users and the citizens than a centralized state solution. So I think it's not only about big tech versus governments, it's also looking at where do we have the best solutions to ensure fundamental rights for citizens and consumers. And there, of course, I mean, it would be good if we had European companies or non-GAFA companies, but I mean, quality must also prevail, and we must allow people to choose the products and the services that they prefer.
Thank you. Chloé, your thoughts on this, on the motivations behind?
Yeah, on the economic motivation, we still had, when the AI Act was discussed, the Artificial Intelligence Act, we still had a lot of echoes from policymakers that maybe we shouldn't regulate too much, or we should go light touch on this area, because well, we want to get European companies to innovate, and we don't want to put too much regulatory burden on them. So there was still a little bit of competitiveness framing in there. And it took us a lot of efforts, civil society, to organize and actually shift the debate to maybe you missed a whole angle about this debate on AI, and the one of values, but most importantly, more than values, actually rights. And how do we respect like the fundamental primary legislation that we already have in place. We want to, we usually try to push back against the framing that we want to be in this harm race with the US and China, because this is not the kind of type of terms in which we want to compete. If this is to reproduce the same business models as the US, I'm not sure it's actually desirable to go in a fight and in a race with the US. Like who is going to breach the most fundamental rights is not really interesting to us. So, and there is this kind of second point I want to mention, and it's if it's a European kind of production, like say, or if it's like sovereign, we achieve this European sovereignty in the digital era, then it's fine. It's like if it comes from Europe, it's taken as granted that our values are going to be respected, rights are going to be respected. But is a false idea, really, that as soon as you achieve this, then necessarily all rights will be respected and there will be less violation, less problematic issues with the technology we develop and deploy and use. I want to take a little tangent because my area of expertise is more law enforcement, but it's an interesting kind of comparison in the reform of Europol. So the agency recently got a new mandate. There is a whole part of the reform that wants to give Europol more decision power in terms of research and innovation in the field of policing and surveillance technologies. So Europol would be able to develop its own algorithm, but also take part in the decision making over what fund to allocate, what EU funds to allocate to research in the policing sector. And one of the arguments that was underpinning this reform and this measure was actually like, we don't want to rely anymore on foreign tools for policing because criminal justice and law enforcement is a very sensitive field and we want to be in control. Fair enough. But then it was like kind of taken as a red herring or as a like, don't worry, it's going to be developed by us. So it's fine. We're going to have de facto less bias in our tools. There's going to be less discrimination or discriminatory impact. Don't worry, if it's like produced at home, then you don't need to care so much. And this we had to fight back a lot, and it was hard for the policymakers to actually hear that. It's like, oh, we're not longer relying on these Israeli companies or these American companies for surveillance tools. Doesn't mean that the European ones will be better. Yeah, and so on the motivation, just as a sum up, like also we see data protection being used as a kind of a tool or a smokescreen, but actually it serves nationalistic interest most of the time. At least historically, it's also how the digital market developed with like some real struggles between nations and who would get the most like advanced technologically, and digital like tools is not an exception to that. So in that case, it's clear that it's not really about fundamental rights and data protection rights.
Thank you very much for this intervention. Xavier, your point of view on that, do you think that simply making something in Europe automatically makes it safer, or is there some work that actually needs to be done?
Yeah, just before that, would like to get back to the for us the real question: who is concerned by this regulation, GDPR? Everyone is concerned, meaning people, users, organization, public organization, cloud provider. We are of course concerned, and we are complying with all those regulations at the European level. And for us, it's not a question. And even member states also are concerned. As soon as we have an harmonized European regulation, meaning GDPR is one of the greater things for us as a legal standpoint, because we hopefully, for OVH, we are a European company, so this is great to have a European regulation, which is the same for all countries in the EU, and we don't have the to take specificities for each country to another. So this is one of the greater things for us about GDPR. That's why we are very supportive on that. It's because of European, this is at European level. Second thing, Chloé mentioned that already, is this is a fundamental freedom to choose where you're to get the control of your data. This is very important for us, and we should continue to maintain that at the European level. Again, even if internet, the network is a global thing, yes, we know, but we have fundamental rules here in Europe. We must protect, share, and be proud of, actually. And the other thing is regarding at the world level, we can see that other country is thinking or working on the kind of same regulation for their own country. And for us, as a European company, this is a plus, because we have the experience of GDPR here in Europe. So when those regulations comes up in India, in Canada, we already we have the experience of such rules, so we can deploy and work with that. We are okay with that because we have that here in Europe, and this is our mother country. The last thing is how we can give more example in Europe about that regulation. I think about Gaia X, which is a label organized by the cloud providers to set up some labels in the industry. And OVHcloud is one of the founding member, around others, of course, company. And the idea is to have in Europe general label we can be used for fairness competitions. So this is one of the key projects we have at that in OVHcloud. We have also following and be part of what the European Commission launched around Alliance for Industrial Data Agent Cloud, which is, I think, very important too, to be part of. And we also take part of the IPCI, which is funding process procedures here in Europe for the future of the cloud service and product. We follow, but actually this is GDPR, and so data sovereignty is more than just GDPR. GDPR is a part of that. We have also other things which is important, which is part of it, fair competitions. We have also certification at the EU level, and this kind of build digital sovereignty.
Thank you very much for this answer. I see a lot of people in the room who are much smarter than me, so in order to give them time to ask questions on top of mine, let us go for the last round of the questions in this moderated part. And I'm going to make it a two-parter. I'll make it sound like it's a one question, but it's actually two of them combined, and you're free to choose whichever you want to answer. So the first thing that interests me a lot is when you look at the rhetoric around digital sovereignty, the question is, who do we want to be sovereign from, right? Who is the opponent we have here? And we often focus on the big tech, on GAFAM. It is essentially the Americans, right? That we see as that are presented as the source of potential infringement of our fundamental rights. And of course, the US does not respect right to privacy in the same mindset in which we do. But it seems that there are other countries like China with whom the problem is not only the not reliability of supply chains, but also the fact that they have a very, very different philosophy of sort of what freedom means and does not mean and how digital sphere should look like. And this is the moment when it's actually a second question, but I'm pretending that is one. So what do we do? Is the enforcement of the GDPR, beefing up the enforcement, a way to sort of secure sovereignty from any of those actors? Because we've heard a couple of times today already flashing this idea that maybe we should not centralize, but maybe we should empower a body on the central level to deal with transnational cases, maybe similar to the way in which we do competition. Do you think that this is the way to go, or do you think that this is just a simple idea that would not work? Chloé.
What am I going to answer? I think I'll take the second one anyway.
Go ahead.
Yeah, so like digital sovereignty like is clearly not enough. That would be my answer to your question about like what do we do with the application of the law should be the priority, and we should not hide behind other concepts because, as I said, it's usually a smokescreen to not enforce and not give people the possibility to have their rights respected and enforce their own rights. So the data protection rights question is not solvable in this kind of concept. It's impossible. The objectives are very different as well. You have on the one side this kind of nationalistic or nationalist agenda, which is at odds with the obligation that are like enshrined in the treaties, notably in the Treaty on the Functioning of the European Union, the Article 16. There is the responsibility of the institutions to make sure that people data protection rights are respected and enforced. So we're really talking about two different things that cannot be like completely replace. One cannot replace the other. And so I would try to push back, on this idea of if we achieve digital sovereignty, then we're safer. Obviously, it helps with the application. If the companies are forced to have an appointed legal representative, for example, which is the case of a lot of European instruments recently that forced this kind of localization on one of the member states or have a connection to the European market, then they fall within the European jurisdiction. Obviously, it brings some advantages in terms of how you will be able to apply, like how your authorities for enforcement and oversight will be able to work. But it's not enough again, especially if you think of if you don't have like strong independent enforcement authority, then your project is a bit doomed, let's say. If the state has a strong interest in the processing of data at stake, it doesn't matter if the company is American, doesn't matter if the company is whatever nationality, if it's European or not. There is no incentive to sanction, like if the state has an interest, there is no incentive to sanction itself if the processing is in breach of the law. So in terms of GDPR application, if you think about, like, I don't know, health data, for example, and the states delegates part of the data processing to a company, if there is a breach and there is not a sufficient independent authority that is there to identify the breach and then sanction it, there won't be any action on this violation, and people's rights will be forever continuously breached, let's say. So that's that. And then secondly, like one interesting point, and I thought about it with the member. Let's imagine also we have only like a European force, European infrastructure, and so on. If you think about other states, if they start doing what the European Union is doing, which is more and more extraterritorial application and extension of their jurisdiction, well, it really doesn't matter if your data is localized and your service is also localized on European territory. Like taking the example of the Cloud Act in the US, which is this law about like getting access by law enforcement authorities from the US to data from service provider, which are subject to US jurisdiction, whatever the definition of that means. But it means that if you have the American company that is the mother company, and then there is a European kind of sub-company, like filial, then they fall under US jurisdiction, and possibly they have to disclose their customers' data to a law enforcement authority. But the EDPB and the EDPS released a joint, an opinion on this Cloud Act and said that it will likely potentially breach the GDPR, Article 48, which is about the transfer and disclosure of data not permitted by union law, because that requires an MLAT, a Mutual Legal Assistance Treaty. But the Cloud Act is not one. At least not yet. There is no executive agreement. So this is to say that if you have foreign actors or foreign states that have an intrusive agenda and wants to push and extend their jurisdiction, possibly like whatever where the data is, or if your data is labeled European. And so, as a kind of summary, or an invitation is more that we focus our efforts on enforcing what we have. And for that, EDRI has been working together with its member in its network to develop a series of recommendations on how we can improve the application of GDPR through very concrete means, small fixes that we can do easily. It won't solve the whole scheme, but at least we're participating and contributing to the debate on how we can make it more efficient and better for the people.
Thank you. Karen, your thoughts?
I think we might go from having a fragmented regulation of digital and the internet to actually having overlapping regional legislation such as the GDPR and the Cloud Act that have a global scope. And we need to figure out how we want to deal with that. And I think we perhaps should go and look at, well, how do we make both the private sector and the public sector and civil society work together, and how do we govern digital and internet? And for me, the essential thing is ensuring the protection of rights. And in the EU, we have more legislation on the way than the DSA, than the Digital Services Act and the GDPR. We have the European Data Act, we have the AI Act, and enforcement is going to be key on this. And when we're negotiating, we're looking at the GDPR as both the golden standard and there where we do not want to go, because we want to have effective implementation and enforcement. And there we also have the problem of who are we going to hire to do the effective enforcement of this? Because it's difficult enough to have civil servants that have the skills to be able to compete with the big tech companies. So how are we going to, as it is now, and with more digital legislation, how are we going to continue on that? And there we also return to a part of the problem of why do we have these big tech companies in the US and possibly now in the future in India and in China, is because they have investment in research and universities and a startup environment that makes it possible. So I think we need to try and think a little bit outside of the box and try and see, okay, what is the bigger picture of this, and how do we there's a lot of work cut out for us. How do we make sure that there is effective enforcement? How do we make sure that we have people enough that are capable and innovative enough in Europe as well? How do we attract them? And there it's not just a question of digital legislation, but research and also migration rules.
Thank you. Xavier, your thoughts?
Yeah, just would like to maybe to talk a little bit about what Chloé said, because I'm not sure I well understand, but I am also in charge of law enforcement at OVH, and I can confirm that I'm a European company based in France, and I confirm that only French authorities have the right to request under French law the disclosure of the data. And the rule is clear. We took very seriously the sovereignty. So for the data stored in France, only French authorities have access to that data. And it's the same for other countries inside EU, because we have data center in Germany, we have data center in Poland, and the same rule apply. And the law is clear for us, and we will apply like that. And there are no American authority which is requiring data for OVHcloud, only French authorities. And even if we have activities in the US, we have different infrastructure. So when we are in a country, we're respecting the regulation of the country, and that's all. So just would like to mention that. So this is something very clear for us, and this is a main point we follow for us. For getting back to the question, just GDPR is a main piece of a puzzle of a lot of things for data sovereignty. We have also other bases like the Data Act, like the IUCS certification and other, which part of a lot of things, as Karen mentioned. The main thing is, and the most important for us, is making sure that all cloud provider follow the same rules. So we are following the rules, and we are happy with that. And we expect from our competitor to do the same for fairness competition.
That sounds like a good line
Yeah.
to finish.
Yeah, I'm
Thank
sorry.
you. Christian, would you close us off before we go into the Q&A?
Yeah, just a few brief things. Building on what's already been said, I feel like the GDPR is being expected to solve all of the world's problems, which is not what it was intended to do. It wasn't intended or designed to fix monopolies which behave badly by design. And when we talk about enforcement, I mean, is the solution simply a sort of arms race, like who's got the most lawyers, the most resources? Because they're never going to win, so long as it's the biggest companies in the world that they're taking on who are able to play the judicial system to string out enforcement indefinitely. So, it's not only about the GDPR. GDPR is a horizontal tool, applies to everyone from your local plumber to Amazon. Second thing is kind of related to that, which is like looking ahead. If the globalization is fragmenting, we need to start panning out. Why do we have the GDPR? It's because of the Charter. Why do we have the Charter? Because human dignity in a democracy with the rule of law, and these are the things which are creaking, not only outside the world, in Europe, and that needs to be safeguarded. Because if you don't have the rule of law, then forget about GDPR enforcement. And then the third thing is more of a philosophical thing, and I wonder whether we'll still be talking about sovereignty and autonomy in 10 years' time. I tried to explain that 10 years ago you wouldn't have had this debate, and I wonder again personally whether notions of sort of sovereignty, autonomy, which carry a sense of exclusive ownership, they've become deeply problematic when you look at what we've done to the environment, and we may need a different mental framework for engaging with these issues, but that's for another discussion.
Thank you very much, and thank you for mentioning the rule of law. When Xavier was speaking about only French authorities having access to data being stored only in France, I must say that imagining using a cloud provider that's based in Poland and having only Polish authorities accessing it, I would actually prefer US, but that's a separate thing.
And it's soon no longer the case.
Soon no longer will be the case. Ladies and gentlemen, let us open the Q&A part. We already have a question from Michael, and then here. Do we have somebody with a microphone? Oh, we don't?
Oh. But then the internet can't hear you.
My question is about bottlenecks. Contact tracing issues you mentioned. One of the reasons why that became such a big concern was we realized that neither a centralized nor a decentralized app would function at all without the blessing of Apple. And therefore a choice was made, and the company made a political choice, which was contentious in some member states. So do they control the code that runs on our devices? I think. And that creates bottlenecks which we can use to regulate. And my question is about the European regulations that use those bottlenecks. So the DSA, for example, relies on terms of service to gatekeep speech and content, relies on these bottlenecks being there. The CSAM proposal now also relies on individuals being not really able to run their own software on phones, otherwise it would be an ineffective proposal. And even the Digital Markets Act, or even to the GDPR, even the GDPR relies on app stores and operating systems and browser engines to actually stop tracking much more than regulators have. So are we building, through our regulatory agenda, infrastructures that are too big to fail and actually undermining digital sovereignty by entrenching them and making us reliant on them in order to regulate?
Let us maybe collect, or unless you want to address immediately, then we can do that.
We can do a couple of questions.
Okay, let's maybe get one more.
Hi, my name is Philipp Reth. I'm the CPO of Allianz Insurer. And I think from my perspective, the elephant in the room is also a little bit that we're really missing out on big IT tech providers in Europe, right? So when I, as a company, look for cloud service storage, right, I only have US providers. I look for social media, right, it's TikTok in China or the ones in the US. There's nothing in Europe, right? And the next battle probably will be with AI, you know, who develops the best AI. And I think, Karen, you touched a little bit on that, and maybe we can elaborate that a bit more, really, you know, to help innovation here in Europe, that you know, we have more of these industries. And I think there is really a difference whether you have, you know, also the culture of European privacy with European companies, right? And not exclusively, and it's really exclusive in many areas, relying on these, you know, foreign providers. So I think also from a policy perspective from the Commission, you know, the question is how can we encourage that? And Karen said, you know, immigration, but also I think education, you know, the right programs on the universities, maybe also subsidies for companies. And I think this would be equally important to enforcement, you know, EU rules on foreign companies.
Great, thank you.
On the bottleneck question, I mean, this is also part of what we're trying to do with the Digital Markets Act, where we're trying to break open some of these monopolies. But when we're producing legislation, we're also legislating for the world that we're living in. And to go back to the internet of the 1990s would be great and wonderful, but that's not going to happen tomorrow and may not happen. But we could look at using, for example, more open source and providing more interoperability and choice for the users when we legislate. And yeah, answer that question as an attempt.
Yeah, great questions, and they're sort of related. Yeah, it's true that that we're reliant on a handful of companies for our kit and for our data processing. In the cybersecurity world, it's a risk if you don't diversify your suppliers. That's one of the things that we're working on in relation to 5G technology. So it is a risk that we are running. And we got lucky that Google and Apple decided 2 years ago that they were going to go for one particular protocol rather than some of the other crazy ones which were circulating at the time. I don't know if you remember. The too big to fail question is valid, and there is a big push by this current Commission towards industrial policy. I mentioned the CHIPS Act. We'll see how that pans out. But there are all sorts of reasons why you don't see European companies in the sort of top 50, top 10 list of tech companies. I don't. It's certainly not because of privacy rules. That's a myth. But it is the case that business models took off on the west coast of the US and in China, which probably wouldn't have been possible in line with values over here. But is it really all about data? I'm not sure. I think it's about actually having computing power and being able to solve problems.
Thank you. Chloé, Xavier, do you want to address any of this question?
I mean, I would have a very similar point to like reinforcing maybe what the two speakers just said. Yeah, on the too big to fail, this is also our analysis at EDRI, that most of the legislation in the digital field, they are replying to, they're very much with big tech in mind. Like everything is drawn from this angle and they're not thinking about the rest. And obviously a more diverse ecosystem is all we want. This is what we're striving for. And so when we come forward as civil society with ideas like interoperability and also framing it as a positive aspect for people's rights, people's freedoms of choice, having different business model emerging and so on, we're facing very quickly some pushback and some walls. So this isn't super easy. And I think the reason for that is that this is not in their interest, actually, to have more diversified set of actors, because then when you're like having the system regulation, for example, is so easy. You just have a handful of actors you can identify which are problematic, and you're just like, oh, since we cannot do it our own, we're just going to delegate to those actors. And since you have few, you can control them better. So this is what we also for a long time identify as privatized law enforcement, whatever law enforcement, like law enforcement in a more general sense, like whatever application of laws you want to do. This is so easy to just like delegate it to a few handful of actors because you have identified them, and it's much more easier to like make a set of obligation on them. And this is how they're being used, basically. And it's this power struggle where one tries to avoid legislation and the other is trying to catch up. Or at least this is how I would see it.
Got 2 minutes left. We have 2 questions. So let us hear both quickly and then see what happens.
Thank you. My name is Katerina Matsuka. I'm head of the Latvian DPA. The digital sovereignty, for me, it's more than GDPR, because it's not only personal data protection, it's all of this, and it's more than, it's many human rights, freedom of speech, freedom of information, and all of the things. And now in the European Union, we have a lot of proposals of the DSA, DMA, IE, and etc. So in the end, maybe after 2 years or 1 year, we will have 5 legal acts, different ones. We will have different regulators, because it not only be DPA, it will be different ones in each country. And we will have as well some national rules implementing this legal act. So it's very good in theory, but how it will be in reality? So what do you think would be some methods how to implement it really in reality in a common way, in a common sense way, to not go so going in the one direction for all of this, it's one. And another thing, to have maybe already we have to think about some cooperation mechanisms in the European Union level, how to deal with all these 5 legal acts, because they are still different ones and they provide different rules, and there will be one company or another, like each company, they will have one action, 5 regulators, 6 legal acts, and so how you think it will be doing?
Yeah, it's a great question. I'm afraid we can't answer.
While the microphone moves down, I think we need to have one EU authority that ensures the regulation of all of these different digital acts, because there are so many overlaps and we wouldn't be able to staff 5 or 6 of them. And I mean, we have a competition policy in the Commission.
My name is Jordan Nagle. I'm from the Australian Government's Department of Home Affairs. We're developing our first National Data Security Action Plan. We're in our last week of consultation, so if anyone wants to put a submission, very welcome. The question that we have for the GDPR, we're really interested in the idea of digital sovereignty and whether or not there's a sense that that might expand just from the individual and the individual controlling their information to the idea of potential state intervention when there's a data set that collectively is of more value. So the individual may say, I don't mind, it can travel, but when it sits together, it could then go into a location where it could be used collectively against the national interest of the member states. And the other side of that is whether or not that could be used against the human rights of individuals, because we're looking at data now being harvested and used in different ways. So just interested, I know the GDPR isn't intended to solve everything, and this is a broader question, but it's something that we're considering as part of our appraisal and interested in your views.
Anybody?
Yeah, there's a panel on different enforcement mechanisms, which I can recommend to answer your question. I was involved with the Data Act, and we tried hard to operationalise the recommendation of the EDPS for a coherent enforcement where they're compelled to cooperate with each other, which hasn't existed before. The data, if I understood the question, or data as a national security asset, I mean that's part of the, Chloé was referring to it. Sometimes, you know, countries use data protection as a cover for national security goals, and there is the risk that, you know, we draw a false equivalence between two countries which have laws which look similar, but the underlying state of democracy is completely different, for example. Yeah, I mean, but I think it's going to become an issue. Certainly, if you look at what's happening in cyberspace and the spike in espionage activities and all sorts of actors getting involved from China and North Korea, and it's something to watch. And I wouldn't be surprised if your government ends up drafting a few articles.
Thank you for this answer, and let me finish in an academic fashion. Those are all great questions, but more research is needed. Ladies and gentlemen, thank you for attending this panel, and join me in thanking our wonderful panelists. Thank you all for coming.